Welcome to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight.
Hello and welcome to In the Courtroom and the Boardroom with trial attorney Colleen McKnight. Colleen is the founder of McKnight Law PLLC and a seasoned litigator with first-chair trial experience in state, federal, and arbitration forums. She helps business owners respond strategically to legal disputes before panic and paperwork take over. I'm Kevin Rosenquist, and today we're talking about how to respond when your business is facing a lawsuit and why what you do in those first 30 days can shape the entire case. Colleen, welcome back.
Thanks, Kevin. I'm thrilled to be back with you.
Yeah, I'm interested to talk about this. I mean, it's obviously you get that letter in the mail that, or however you get it served or whatever that you're being sued. That's the last thing people want. So, what do you advise is the very first thing a business owner should do after being served a lawsuit?
Yes, that is such a great question. That is a lot of people's nightmare, that feeling of you've been served. And so first, take a deep breath. We have time, you have options. Sometimes it's not nearly as bad as you think that it is. Second, take some time and read the documents. Sometimes you find out that you're just added as a third party, or it's really just a subpoena that's asking you for some additional documents. So read it, find out who's the plaintiff, who are the players, what are they claiming happened, what are they asking for, and then you need to call an attorney. You need to call someone like me or someone that you trust, because you need to get an answer on file within 21 days in federal court, or in Texas, because everything has to be complicated, it is the Monday following the expiration of 20 days. So somewhere between 21 and 27 days. Often you'll see that the opposing party is willing to give you an extension. It takes some time to read, it takes some time to get a lawyer, but what you don't want to do is just sit on it, because what can happen if you get that lawsuit and you shove it in a drawer because you just can't deal with it, is that you will lose by default. And that is a costly and painful process to reverse. So face it, take a deep breath, and call in some backup so that we can start looking at your options.
So is that essentially, so if you miss a deadline, if that's that 21-day deadline, you're on the 22nd day, are you toast? Is there any ramification, or is there any, can you come back from that?
Yes, you can. That's the deadline. You want to meet your deadlines. But the truth is that courts don't love defaults. They want justice to be done. They want people to show up and participate. So usually what will happen is there'll be a bit of a grace period. The plaintiff's counsel will probably reach out and say, hey, you've been served. Is there something happening here? And then it'll take a while, but the plaintiff has to move for the default judgment. So it's not an automatic, you lose, you goodbye. That's not really how the system is designed to work. But should they move for a default before you've come forward and then the court grants that, you're now behind the eight ball instead of coming in from a position of strength. Mm-hmm. So our system is really not designed for a bunch of gotchas, despite the technicalities that we hear about. Oh, they won on a technicality or they lost on a technicality. Those exist, but not usually procedurally at the beginning of a matter. We want you to be able to show up, but knowing that grace period is there should not give you license for delay, because it still takes time. Once I get a call, which is usually about 7 to 10 days after someone has been served, I have to understand who the players are, understand what the claims are. I need to get in so I understand what our next steps should be. And now you're pushing up against that deadline, and it can be really tricky. So you want to make sure that you move quickly, but without panic.
Right. Yeah. That's key right there, without the panic.
Yeah.
Is there anything that someone should do, whether it's, document preservation or any sort of evidence that needs to be, that they should consider and make sure they've got as it relates to the case, or is that a little cart before the horse?
No, you're exactly right. So usually what I recommend is the second you know you might have a claim against you or a claim against someone else is when you need to start preserving the documents. So let's say you own a business and someone says, hey, I slipped and fell and I'm really hurt. That's the moment that you want to say, okay, I need to preserve the security footage that would show this. I need to get a statement from the employee that was working that day. I want to go back and see, did they actually come in and buy anything? So keep your sales records, right? That's when you want to. Sometimes the first time you're aware that there's a potential claim against you is when you're served with the lawsuit. And so at that point, what we want to do is issue a litigation hold for your company. And it says, stop all of your document retention policies, preserve everything. So stop the automatic email deletion, stop the automatic chat deletions. It's expensive to hang on to all that data. And while a lot of people keep things in the cloud indefinitely, you'll notice your text messages maybe only go back a year. So if you get a lawsuit and part of the evidence is a conversation you had over text 9 months ago, you need to preserve those texts and call AT&T or T-Mobile or whoever it is and say, hey, I'm going to need these, or get screenshots of them and preserve them so that they don't just disappear on you. Sometimes, if it's your own data, you can go back and issue a third-party subpoena to Google, to AT&T, to T-Mobile, and say, I need my own records going back further. That's a saving grace, but it's going to cost you expense, time, worry that it wouldn't have if you had just preserved it on your own. And the worst thing that can happen to you is to know I had a conversation where they agreed in writing to what happened, and now they're claiming they didn't, but I can't get my hands on it, right? That's the last thing that you want.
That'd be so frustrating.
And maddening.
Mm-hmm.
And even worse is if it's something that they claim would be good for them, and the court says, hey, you deleted that after you were served. And so I'm going to tell the jury that the reason you deleted it is because it wouldn't have been good for you. And they can assume that with whatever was in that conversation would have really hurt your case. Mm-hmm. And so you want to preserve those documents. And it's something that in the heat of the moment is sometimes easy to forget about, right? You're trying not to panic. You're trying to run your business. And you're trying to deal with this claim that you know is going to cost you some time and some money, if not a ton. And remembering, okay, I need to set this procedure into place to hang on to the evidence isn't always your top priority. So having someone like me to come in and say, I'm going to issue this letter, send it to every employee and vendor so that you don't really have to be thinking about that, will help you make sure that you're not in a position where a judge is telling the jury that you're a bad actor who hid bad evidence, or you're left in a position where you know that you had something that would be dispositive about this dispute, and you simply can't get your hands on it.
Right. I've heard of situations, talked to lawyers before about, businesses, wiping camera footage, doing shady things, getting rid of evidence and all that. Obviously, we know that's wrong, but can you talk about why that is so bad to do?
Yes, because whatever is on that tape, whatever is in that email is not going to be as bad as what a juror's imagination could put in it, right? We often hear that the cover-up is worse than the crime.
Right.
When you're going to go and say, I want this gone, I want you to wipe it, I want you to delete it, you're really putting yourself in a terrible situation. I had a case many years ago where there was a major failure on a piece of equipment. And one of the engineers that was there thought this thing broke and threw it away. And it was at the Texas Supreme Court over, hey, it was spoliation. They threw it away because they didn't want you to see what that part looked like, because they didn't want to be responsible for what had happened. And it was an honest mistake in that situation. The person on the field dealing with an oil and gas piece of equipment wasn't thinking through the lawsuit, but it cost that company dearly. And so you want to make sure, you want a CYA ahead of time, but once you get that notice or that lawsuit, just preserve it. I promise you that a good advocate can do more with what it shows or what it says than with you deleting it.
I mean, you're talking about a case where this person was legitimately didn't have any ill intentions. But if
Right.
if it looks like you had ill intentions, like that would be, yeah, way worse.
Right. And the jury's job is to decide credibility,
Mhm.
right? The judge doesn't do that. And so when you're talking up, you're standing up and you want to say, I wear the white hat. I'm the good guy here. I handled this with honor. I did everything I needed to do. This part still failed, or I did everything that I needed to do, and they didn't complete their end of the deal. When you go with bad intent and delete something, or with good intent, but the judge tells the jury they can assume it was bad intent, you really suffer. And not just in that little instance, you're suffering overall because now the jury's looking at you and they don't know if they can trust anything you say.
Right. Right. Yeah. Is it ever an okay idea to reach out to the party who is suing you? I mean, if you know the person, if you've had a business relationship with them, or is that generally something you advise people not to do?
It really is situation dependent. Sometimes bringing the lawyers in really does complicate it. Um, and the business people can see eye to eye more quickly. In my experience, if a lawsuit is being served, we're probably past the point where the business principals are just going to be able to come to their own resolution.
True.
Somebody has thrown the gauntlet down. And so talk to a lawyer first, get their advice. They may say, hey, give them a quick call. Maybe this was a rogue vice president or someone within the company was, pissed off, but you can get to the CEO and they're going to cut this madness off. Don't make that choice without your lawyer's advice. But often I will say, why don't you pick up the phone and see what is it really going to take to get this gone? Or what is it that they're really looking for here? Are they mad and they wanted to drag our name through the mud in a publicly filed lawsuit? Or are they trying to file the lawsuit to CYA something else? They've got a force majeure provision with someone else and they're trying to prove that our breakdown was the cause of that so that they're not in trouble with their next step. There might be other reasons that you can get to a business solution pretty quickly. But once the lawsuit is filed, uh, you really do need a lawyer guiding your steps because a lot of what you say is admissible.
You brought up earlier if there's somebody had a slip and fall or something like that, at what point do you need to reach out to your insurance company, if assuming that that's relevant to the situation?
That's a really great question. And it really depends on your insurance and it depends on the stage of the claim, right? So let's say you run a restaurant and someone says, hey, I drank too much the other night and I slipped on my way out and I'm really hurt. Do you have anything to show? I can't remember that. Right. At that point, you don't actually have a claim on your hands. So you don't want to involve your insurance company because they're not asking for money or claiming that it's your fault. Once somebody says, hey, this was your fault, there was water on the stairs and it shouldn't have been there, or, the sidewalk wasn't properly repaired and it's the reason that I tripped and it's your fault. You probably want to go to your insurer at that point because they often have pretty strict notice provisions that if you don't come to them with notice within a certain amount of time, they can waive their coverage.
Okay.
The caveat to that for me is cyber insurance, which is really important for business owners. And depending on the scale of what you're dealing with, you may not want to involve your insurance because too many claims could get you dropped. So I want you to picture, it's a little parking lot fender bender. That may not be something that you put to your insurance if the person who ran into you says, hey, I'll just cover the costs. Sorry about that. And you go get it repaired. Similarly, with your business insurance, you may not always want to include your insurer if you think this is a smaller claim. I'm just going to deal with it off book. Because what we see, unfortunately, is a lot of insurers will drop you after a few claims, or even if it isn't your fault, you'll be prevented from getting further insurance or an umbrella policy later. And that's unfortunately the state of insurance at this point. And so, again, I would talk to your lawyer first and say, does this look like something we want to tender to the insurance. One of the big things, Kevin, with that is that insurers will often insist on their own counsel to fight those fights. And what that means is either you're going to pay the difference for your chosen lawyer from what the insurance is willing to pay, or you're going to have to let your lawyer go and go with the insurance lawyer. And there's lots of wonderful attorneys that defend insurance, but it is a volume practice. They tend to have lots and lots of cases, and it's probably not the person you chose. So, you pay for that coverage, you pay for that defense. You should definitely consider it, but you may not necessarily want to use it if you think this person I've chosen is going to be more efficient and do a better job of fighting this fight, or I'm willing to pay the difference to have my chosen person.
Other than some of the things we've talked about, are there any other common mistakes that you see business owners make in that beginning stages of a lawsuit?
Yeah, I would say, in the effort to defend yourself in 2025, don't go to social media. Don't speak to the actual media. This isn't your time to go defend that. And what you say in those moments, it's not as critical as a Miranda warning for a criminal case, but what you say is going to be part of the record. It's going to be discoverable. And so, take a deep breath, keep it with your close circle, get some advice, and just be careful not to go and air it, even if you feel like, wow, this complaint is really a press release against me, right? This is really them trying to write the narrative, and I want to get my answer out there before my answer deadline. And I don't want it to be in stuffy legal language. I want it to be in my voice. There may be a PR strategy along the way, but get that advice before you go to the public square to defend yourself.
Yeah, that's really, really good advice. I mean, we're all, we could talk about social media all day, but the pros and cons. But yeah, I mean, I've seen people do that where you're just like, ooh, you shouldn't be putting that up there. That's probably not good. I see that a lot in like people that their marriages are falling apart or stuff like that,
right?
And they're posting stuff, and you're just like, this can't be a good idea. This can't be a good idea.
It's never going to work out for you. And, monitoring maybe what the plaintiff is saying could be really helpful for you. But, just keep your cards closer to your chest.
That's a good way to put it.
Litigation is often described as a chess match, right? And you want that strategy to be part of what you are doing in the overall picture to win. And so, it's very tempting to try and clear your own name or vindicate your story, especially for business owners that start to feel the burn early, right? Like, oh no, they've said this about me and I'm noticing a drop in my sales, or I'm noticing it's trending on X or on social media. Just take a beat, circle the wagons, and let us provide you with a strategy rather than just have to react to what you've done in the heat of the moment.
Yeah, that's definitely good advice, because we're all emotional people, like it's to some degree, and we, reacting in the heat of the moment rarely leads to good outcomes. I feel like in those situations.
I understand.
Sure.
Your business is your baby. This is something you've put your blood, sweat, and tears into. And so, someone like me whose job it is to protect it, give me every tool I can get, and don't tie a hand behind my back because you made a statement publicly that now I have to deal with.
Well, great advice. As always, obviously getting sued doesn't mean you're doomed, but ignoring it or reacting emotionally, as we talked about, can definitely cost you. So if your business is facing a legal threat, Colleen McKnight is here to help you take control. Learn more at mcknightlaw.us. And don't forget to subscribe to our channel. Leave us a review. We greatly appreciate it. Colleen, always great chatting with you. Thanks so much for your time.
Thanks, Kevin. I appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.